I'm going to just give you the bottom line ruling now, and then I'm going to tell you how I got there, just for purposes of the order. I'm finding that the statute in section, I think it's House Bill 5, is unconstitutional in that it violates the privacy provision of the Florida Constitution and does not meet the standards of the three Florida Supreme Court cases that have interpreted the effect of that constitutional provision and abortion in Florida. So I will be entering a temporary injunction. It will be a statewide temporary injunction. Will only be effective when I sign an order, so it will be not today. So I have made some notes in the time I had, and then there's some other comments that I don't have notes for. So Florida passed into its Constitution an explicit right of privacy that is not contained in the U.S. Constitution. The Florida Supreme Court has determined, in its words, quote, Florida's privacy provision is clearly implicated in a woman's decision of whether or not to continue her pregnancy. In other words, on the issue of abortion, the Florida Supreme Court has decided that women have a privacy right under the state constitution to not have that right impacted up to 24 weeks at least. Further, the Florida Supreme Court has found, quote, if a legislative act imposes a significant restriction on a woman's right to seek an abortion, the act must further a compelling state interest through the least intrusive means. That's the test of the Florida Supreme Court. Here the act effectively bans, with extremely limited exceptions, pre-viable abortions previously permitted under Florida law. The Florida court has held that the Florida right of privacy is, quote, much broader in scope than that of the federal Constitution, end quote. In the case of T.W., Justice Grimes, in his concurring in part and dissenting in part decision, wrote, quote, if the United States Supreme Court were to subsequently recede from Roe v. Wade, this would not diminish the abortion rights now provided by the Privacy Amendment of the Florida Constitution, end quote. In 2003, the Florida Supreme Court wrote, quote, any comparison between the federal and Florida rights of privacy is inopposite in light of the fact that there is no express federal right of privacy clause, end quote. The Florida Supreme Court has explicitly rejected the federal standard that required a petitioner, in this case that would be the plaintiffs, has rejected the standard that required the plaintiff to prove that a regulation regarding abortion has the purpose of placing a substantial obstacle in the path of a woman seeking to assert her rights. Thus, the plaintiffs in this case do not have a threshold requirement by which they must show with facts and factual findings that a law imposes a significant restriction on a woman's privacy rights. The defendants concede, as the Florida Supreme Court has held, that HB 5 is subject to the standard of review which the Florida Supreme Court calls strict scrutiny. Thus, per the Gainesville Florida Supreme Court opinion, any law that implicates the fundamental right of privacy, regardless of the activity, is subject to strict scrutiny and therefore is presumed to be unconstitutional. In that case, the burden is on the defendant to prove that the law advances a compelling state interest through the least restrictive means. Here, the asserted interests by the state, as outlined in its argument today, are not legally sufficient to justify the statutory ban. I find the testimony of the plaintiff's witnesses is more credible and rebuts that of the defendant's witnesses. I generally agree with the position set forth by the plaintiff in the plaintiff's reply memorandum and in the plaintiff's oral argument today. I was prepared to go through it in more detail, but I'm not sure in light of the time and length of time we've discussed these issues if that's necessary. I think the pages 6 through 12 of the reply memo reflect many of these facts. I do find the state has failed to prove by convincing or credible evidence that this law, HB 5, exhibits a compelling state interest to be protected. I accept and incorporate the findings of fact by the plaintiffs, as I'll give you in more detail in pleadings and in our argument. For example, this is an example of some of the findings of facts that I think are appropriate. I'm not requiring that they all be put in. What I want to identify what I think has the evidence supports. And in the reply memo, I'll just do this by paragraph number with some edits to a couple of the paragraphs. So in the reply memo, I'm looking at let me find it. Well, I think I'm just going to go through subject area, and I will give you other factual references in witness declarations. But in the reply memo, the argument on page 4 deals with, under binding Florida Supreme Court precedent, the plaintiffs have established a substantial likelihood of success on the merits, as I've indicated, and I agree generally with the rationale used on pages 4 and 5. Page 6, HB 5's ban does not advance but rather undermines maternal health. Page 6, I agree with that. On pages 6, 7, 8, 9, and part of 10, the state's asserted interest in fetal pain is legally insufficient to satisfy strict scrutiny and unsupported by the evidence. I'll discuss that when I give you some more detail on how I weigh the experts' testimony. And I accept the reply memorandum up to plaintiffs are entitled to a facial temporary injunction because there is no set of circumstances in which the state can constitutionally deny any pregnant person the ability to effectuate her decision to have a pre-viability abortion. I also find that the plaintiffs have standing to assert their privacy rights as discussed in the reply memo and as further articulated today in the argument by plaintiffs' counsel. I find that this is a proper facial challenge as articulated in the plaintiff's reply memo and in today's argument. I find that the elements of temporary injunction as outlined in the reply memo and as discussed by plaintiffs' counsel today have been met, the 4 elements. So I would request that the plaintiff the order contain that. Now this will take me a little bit more time, but I'm going to go through some of the notes here. I've addressed standing. Plaintiffs have demonstrated irreparable harm, that the temporary injunction is in the public interest, and that the injunction shall be statewide. On the issues relating to science, the science and medicine of abortion, I find plaintiffs' experts, Dr. Teen, more knowledgeable and credible, and her testimony better supported by scientific and medical literature, as well as her extensive experience as a medical doctor in the areas of maternal fetal medicine and obstetrics and gynecology than I do the witnesses provided by the defendants. Dr. Kondik, who is testified as to the pain issue, is not a medical doctor and has no direct experience in counseling women on abortion or in performing abortion procedures. I do not find Dr. Kondik's opinions as to a fetus being capable of feeling pain at less than 24 weeks is properly supported by the available scientific evidence. I find Dr. Teen's testimony that the earliest a fetus can experience pain is at generally at the 24-week plus weeks based LMP, last menstrual cycle, based on the fact that the brain is not sufficiently developed before then to make the feeling of pain possible. Even if one dates the fetus feeling pain from the last menstrual cycle, Dr. Kondik would add 2 weeks to her 10 to 12 week period. If this is accepted as accurate, which I do not, it would mean that within the 15th week of the new law, a fetus would be able to feel and appreciate pain. Therefore, eliminating the possibility of fetal pain, it cannot be an abiding state interest supporting the statute because it would still permit such pain based upon the expert testimony. I, however, do not accept that expert testimony is accurate or as being more credible than Dr. Teen's testimony, which I do find is more credible and scientifically supported. The more persuasive and reasonable interpretation of the evidence would indicate that the ability to feel pain at the earliest begins at 24 weeks, which has previously already been established by state law as the cutoff of the permissibility of an abortion because the fetus is considered to be viable at that point. Therefore, the fetus, the scientific evidence supports the conclusion that due to lack of brain development, fetal pain or ability to feel and recognize pain doesn't start until approximately the 24-week or 24-plus week period. Therefore, avoiding fetal pain cannot be a valid basis for reducing the abortion period from 24 weeks to 15 weeks. Dr. Kondik also testified that the fetus is capable of self-awareness and consciousness at somewhere between 14 and 20 weeks LMP, which I do not find to be supported by the most persuasive evidence in this case, again because of the lack of the brain development at that stage. As I recall the evidence, her opinions are contrary to those of the American College of Obstetricians and Gynecologists. I believe also, and this is subject to verification, the Royal College of Obstetricians and Gynecologists and the authoritative Journal of American Medical Association article reference published in 2005. As to anesthesiology for fetal surgery, I reject the opinions by Dr. Kondik that this is done to alleviate fetal pain, but I accept the explanation by Dr. Teen, who has actual experience as a team member for fetal surgeries as a maternal fetal medicine specialist, and Dr. Kondik does not have that. I accept Dr. Teen's explanation. Also, Dr. Kondik testified, this is in, I think, her testimony, at page 268 in the case of Planned Parenthood versus Minor, that at 18 weeks LMP, last menstrual period, a clear and ambiguous case would be difficult to make that we have neural circuitry in place for a fetus to have a conscious awareness of pain. Her contention in this testimony that conscious awareness of pain would be possible with just the thalamus and without a choroidal connection is not as persuasive as Dr. Teen's testimony in the scientific sources she cites. With respect to Dr. Scott, she is a OBGYN, 30 years practice, And she has never performed an abortion or participated, as far as I know from her testimony, in an abortion procedure. I'm not sure if she's witnessed one or not, that her testimony would have to be checked, but also her practice. The members of her practice, when she was in private practice, did not participate in abortions. She stated that she is not an expert in mental health evaluations or in the mental health area, but part of her testimony relates to mental health. Dr. Biggs provided a detailed written response to Dr. Skopp's opinions in regard to the abortion and mental health issues, those issues as they relate to each other. Dr. Biggs has a PhD in psychology for over 20 years and is a faculty member at the University of California, San Francisco, and has an incredible educational, research, and professional activities background as reflected by her CV, which is incorporated into this order. She has extensive national and international experience, service to professional publications, invited presentations in this country and internationally. She has 84 peer-reviewed publications and 3 book chapters. By reference, a peer-reviewed publication, as I understand it, is the highest rated professional publication for medical literature that exists. Her written statement, which has been admitted into evidence, precisely and persuasively rebuts the positions of Dr. Skopp on the mental health issues. Her analysis of the scientific literature is thorough and persuasive. For that reason, which is unusual for me, I adopt her statement admitted into the record and incorporate it into this order, her written declaration. The findings she makes in there and the analysis she makes, plus the footnotes, are the best evidence in this case in regard to mental health, and are so detailed as to be an example of the proper way to discuss scientific evidence and to rebut another person's testimony with regard to scientific literature. Also, I find, which I think I mentioned today in a question, when the state set the 24-week cutoff date, the state of the quality of health care and of the procedure in question was not better than it is now. In fact, the evidence indicates that the medical procedure that we've discussed and procedures are better with fewer consequences, fewer risk, and lower mortality than was the case in 1980. So, with the risk of abortion before 24 weeks is low, very low, and that's set forth in Dr. Teen's testimony. I think she identifies the mortality risk of abortions lower than some dental procedures. She didn't specify which ones, but also of colonoscopy and other procedures. Even though there are risks with abortion, as there are with any medical procedure, the testimony of risk in this case is sufficient to impair the right of privacy with regard to this procedure, especially in the light of the fact there's no credible evidence that the risks have increased since 1980. In fact, the risks have decreased since 1980.